As the nation navigates seismic legal developments against former President Donald Trump, there is a major decision from the Supreme Court in the case of Allen v. Milligan that we also need to talk about. In a 5-4 decision with Justices Roberts and Kavanaugh siding with the liberal justices, the Supreme Court upheld Section 2 of the Voting Rights Act. Okay, let me explain this. This is significant. Section 2 of the Voting Rights Act prohibits any voting law practice or map that results in the denial or abridgment of the right of any citizen of the United States to vote on account of race or color. The Voting Rights Act, which was signed into law in 1965 by President Lyndon B. Johnson, it is a critical piece of legislation. It is the law that outlawed the discriminatory voting practices that were adopted in many states, southern states, after the Civil War, including literacy tests and also prerequisites to voting. The Voting Rights Act enjoyed bipartisan support for decades. Republican President George W. Bush signed in 2006 the longest reauthorization of the Voting Rights Act ever. And he touted it, took credit for it. So this week, the Supreme Court upheld a lower court ruling that Alabama violated Section 2 of the Voting Rights Act by packing its black voters into just one congressional district. That is the blue portion you see on your screen, diminishing their voting power and sending lawmakers to Congress based on unconstitutional maps. This ruling was a surprise. Why? Because about 10 years ago, the Supreme Court, it was not shy about its willingness to gut the Voting Rights Act, gutting Section 5, the section that talked about preclearance, i.e. the section that said that if states wanted to make changes to their voting laws, they needed to, check in with the federal government to make sure they weren't doing anything discriminatory. To be clear, the Voting Rights Act has been on life support since 2013, since that Shelby v. Holder case that gutted it. And people were bracing across the country for if Section 2 was going to be upheld, because if not, it would have been non-existent. Well, while today the Voting Rights Act is far from safe and majority black districts are eroding, according to Bloomberg, redistricting after the 2020 census, it did cut the number of majority black voting districts across the country from 22 to as few as 9. That's why this decision is so critical. Section 2 gets at the heart of why the Voting Rights Act was necessary in the first place. It's seen more litigation than any other part of the legislation. According to the Democracy Docket, there are 31 Section 2 cases in 10 states still pending in federal court. Joining me now to discuss more and the importance of this landmark case is one of the plaintiffs in the Alabama case, Khadijah Stone. She is the Chief Field and Campaign Strategist for Alabama Forward. Khadijah, I am just so excited to talk to you. Just what was your initial reaction to this ruling? You have been an organizer in Alabama for decades, frankly, at the forefront of this fight.
Yes, well, first I want to say thank you so much, Simone, for having me on here. It's truly an honor. So I was actually in the beauty supply store and I immediately burst out in tears. I have a feeling of pure joy. I was very optimistic, but I was also, realistic about, what kind of court we're really dealing with here. So my overall feeling is ecstatic, joyful, happy, but I do understand that the work is not over.
So let's talk about some particulars of the case. The state of Alabama argued that there couldn't be an additional black district without prioritizing race over other district and its mapping factors. You and your team proved them wrong. And I was reading in the decision that you all actually provided a number of maps to the justices in your, case, detailing how there were so many other ways that these maps could have been drawn that protected the participation of black voters in Alabama.
Yeah, Alabama, we have 7 congressional districts, and each one of those congressional districts represent 14% of the population. And we found in the 2020 census that the black population of Alabama was 27.79, but it would be rounded up to 28%. And so if you add 14 plus 14, that's 28%, which would automatically equal 2 congressional districts. It's pretty easy math. We weren't asking for something that was out of the way. We were asking for, what black Alabamians in particular are owed.
So now that the Supreme Court sided with the district court that, again, originally sided with you all, these electoral maps are going to be redrawn in Alabama, it's my understanding, before 2024. What is that process?
So typically the process is the governor would call a special session focused on redistricting, and then the reapportionment committee would come together, decide how they want to draw the maps, and then they would go to the legislator, the House, and then they would go to the Senate, and then the governor would sign for the maps to be installed.
Do you have any, have you all heard from Governor Ivey if this is in fact something she plans to do with urgency?
I have not heard anything, but because the Supreme Court has ruled, I would hope that she would do what was right.
We will be watching that. Okay, let's talk more broadly, Khadijah, because the reality is that there has been a surgical assault, I would like to argue, on the participation, on the political power, if you will, of Black voters and then specifically Black elected officials across this country. You all winning this case has ramifications that reach far beyond Alabama. What do you think this means for the fight going forward?
Yeah, so there are other states, especially when we talk about congressional maps, there are about 12 other states who are also suing their state for violating Section 2 of the Voting Rights Act. And each one of those states were actually told until they ruled on this case that they could not give them a proper answer until the answer for this case came out. So I'm looking forward to seeing what can happen for the other states. And I would hope that those states do right and abide by what the Supreme Court has already ruled.
So Justice Kavanaugh, a deciding vote in this case, but he only concurred in part of the case. Now, how confident are you that Section 2 is safe, that it's going to remain unharmed under this particular court?
Well, we are grateful that the Supreme Court upheld what we knew to be true, that everyone deserves to have their voices heard. This ruling does prove that politicians cannot weaken our community representation by distorting congressional lines, particularly in Alabama. But like I said earlier, this fight is far from over. Our Constitution does not explicitly establish the right of voting age citizens to vote and have their ballots counted. And so this must change because we know more attacks on Black and brown people's right to vote will come. And like you mentioned earlier, you referenced the Shelby County v. Holder case. We're very aware that the reason we're here today is because they struck down sections 4B and 5 in that Shelby County v. Holder case. So that's why we must remain vigilant of all the efforts and fight against what they are doing, which is trying to suppress the Black and brown vote across not just in Alabama, but across the country.
It is something to be vigilant about. Tomorrow I'm going to speak with Congresswoman Terry Sewell, whom I know you know well, about this very issue and the ramifications going forward. Khadijah Stone, thank you very, very much for your time. Appreciate it.
Thank you so much.